This is Michael Popok, Legal AF After Dark. Want to know more about presidential immunity, what it is? Why isn't it in the Constitution? Does it apply to civil cases that are being brought against Donald Trump? Does it apply to the indictment brought by the special counsel Jack Smith in the District of Columbia? What's it all about? Popok and Ben Meiselas on the most recent edition of Legal AF podcast, only on the MeidasTouch network. We debate it, we talk about it, we explain it. We start with constitutional concepts, Fitzgerald and Nixon, Clinton and Paula Jones, and we bring it all together now and how it applies to Donald Trump. And here's a clip.
So let's talk about presidential immunity, Michael Popok, and just the concept of immunity in general. Immunity can be created by statute, by law, that prevents lawsuits or cases from being brought against specific people. I'll give you an example. In the Constitution, there's speech or debate clause immunity, which prevents members of Congress from being brought into court or from being sued for any of their conduct relating to legitimate legislative activity. Also, while there is no express language about the immunity of presidents in the Constitution at all, the Supreme Court, in a series of cases dating back for decades and being kind of synthesized in the Nixon era and then refined with some cases involving Bill Clinton, developed a doctrine stating that based on the structure of the Constitution, there's a doctrine called presidential immunity, that the founders, that the drafters of the Constitution must have intended implicitly within the constitutional regime that if a president is sued civilly, that could harm their ability to function and to do the jobs that they're tasked with under the Constitution. So you've got this case, Fitzgerald versus Nixon, which is an employment civil case for retaliation, wrongful termination by Nixon against Fitzgerald, where the Supreme Court said, even if engaging in retaliatory, unlawful termination of an employee may be viewed as an unlawful act that nobody would ever condone, because it falls within the outer perimeters of the responsibilities of what an executive, what a commander-in-chief is supposed to do, hiring and firing. A president will be protected in civil cases involving lawsuits brought even in the outer perimeters of presidential duties and responsibilities. Then you had a case involving Bill Clinton, Jones versus Clinton, involving conduct alleged against President Clinton before he was in office. There, the Supreme Court said, well, clearly conduct that takes place before you're in office or after you're in office, not while you're in office, that conduct clearly should not be subject to the broad sweep of presidential immunity here. And so in the case involving individuals who were injured on January 6th, DC police, Capitol Police, and members of Congress who brought the civil lawsuit, another question had to be raised. Did Donald Trump's conduct on January 6th fall within the outer perimeter of their constitutional duties, even if it was unlawful and illegal for purposes of civil case, like the Fitzgerald case involving Nixon? Or is it more like Jones v. Clinton, outside of the scope of presidential immunity, because he's not the president? And I want to hear your analysis there on this civil case, Popok, and how we got here. But ultimately, the reason that it's more like Jones versus Clinton, this three-judge panel, one judge was appointed by Clinton, one judge was appointed by Obama, and one judge was appointed by Donald Trump. What those judges ultimately agreed with is Donald Trump's conduct was in connection with campaigning, was part of his election functions. That's outside of Article 2. That's not within the outer perimeter of what a president does. It clearly falls outside of that. But how do we get here, Popok? But I wanted to give people a background in presidential immunity and the case law here, and then you can kind of get into the weeds here of that court analysis and procedure.
Yeah, and I think we've got an amazing, we don't normally get back-to-back decisions on presidential immunity, civil and criminal, ex-president, president at the time, in 1 week span in the same location. First of all, as Judge Chutkan said in the other case we're going to talk about, in which he found no presidential immunity to stop a criminal prosecution or indictment of Donald Trump, to have his indictment dismissed. She said, in, I don't know, the history of the Republic, there's never been another ex-president or president that's ever been indicted. So I don't think we're going to open the floodgates, as Donald Trump's lawyers like to argue. Oh my God, this is the sky is falling. If you allow this and you don't impose presidential immunity, all the presidents in the future and the past will have been indicted. That hasn't happened ever. So in 45 former presidents, 45 former presidents, we never had it happen. So what this unique moment in time that you and I are standing, you and I probably don't even realize, and certainly our audience doesn't yet, how unique of an event, series of events happened just this week. You got the DC Court of Appeals, as you outlined, which is the boss for Judge Chutkan, ultimately setting the precedent for the District of Columbia and all of its judges, which are really all the judges that matter now when we talk about Donald Trump federally and related to anything related to Jan 6, because it all emanates from there. And then you've got Judge Roberts, who is he's the Chief Justice of the U.S. Supreme Court, but he also has another role. He's the administrative circuit judge that sits over the D.C. Circuit. He's the first stop on the train for an appeal coming out of this courthouse, this courtroom that we're talking about. And I never thought it was that difficult of an analysis, and certainly Judge Chutkan didn't either, and certainly she was buoyed and got the wind on her sail very quickly by the ruling just 2 days before she issued her ruling. Both these courts were sitting on related but not identical issues, as you mapped out, and how you apply Nixon versus Fitzgerald and Jones versus Clinton in terms of the civil criminal, former president, ex-president, non-president, if you will. And how do you apply that under what the framers and the founding fathers wanted in terms of giving immunity at all to a person who happens to have held the title or was going to hold the title or used to hold the title of president? And so Nixon v. Fitzgerald, for me, just to tap on that for one more moment, I thought it was pretty clear from reading it. And in that one, as long as you said, and as this has been developed between the 1980s and 1990s in these couple of cases that you mentioned involving Nixon and Clinton, if you're inside the outer boundaries of official duty, then you have from civil liability for being sued, not in crimes, not being indicted, being sued by somebody for damages, you're going to have immunity, because we don't want our presidents we don't want our presidents to be sued for doing something that's well within at least the boundaries of their official acts or those outer boundaries that have been established by case law. That's why you and I always comment in our hot takes about judges struggling in, let's say, a removal statute to try to take a case from state to federal court with what are the outer boundaries. Like when the judge in Georgia turned to Mark Meadows' lawyer and said, give me the outer boundaries of your client's role as the chief of staff. I need to understand them. And he couldn't answer it. And courts always have to figure out what is the box of official acts and how far does that box and its boundaries stretch, because they've got to apply this case law that says if it's inside the box and it's civil and that guy was president or that person was president at the time, immunity. Outside the box, or he wasn't president at any time during these relevant periods, probably not. No immunity. Criminal is a whole different thing. Even the court in the 5-4 decision in Nixon versus Fitzgerald, Supreme Court in 82, said if it's a criminal act, all bets are off. We're only talking about civil here. And that if a person is criminally indicted for something within either an unofficial act, something outside their duties, and that's what we'll get to next, or outside of that box, or criminally doing their official duties, they're going to get nailed. They're not going to have presidential immunity. And as Judge Chutkan said in her ruling, which we'll dive into in a minute, there is no, and the framers of the Constitution did not put in a presidential immunity clause. You can, all the textualists and originalists at the Supreme Court and other court levels can go searching and go read line by line the Constitution. And there is not a provision expressly in the Constitution to not prosecute a president, former president, ex-president, current president, whatever it is. And so you got to get to the bottom of this. And it's relatively easy because the president under the Constitution has no role in the electoral process. Does not. The vice president does. That's back to the pressure campaign against Pence. The vice president has a defined role in the Constitution and in other statutes passed after that in terms of the electoral vote count and presiding over the Senate for it and certifying the results of the election. The president's just a candidate. It's the candidate running against the other guy at that moment. There are many things a president has the power to do, as defined by the Constitution and by case law. But things related to his own election, that's called campaigning. That's called, I want to stay in office. And now you're outside, and now you're firmly in that area with no protection. You're just out in the open. That is where it's appropriate for criminal liability. So the good news for Judge Chutkan in ruling on criminal conduct of a person outside his official duties, and then looking at what the framers wanted and the Federalist Papers and Alexander Hamilton wanted and all the analysis that she does, because she's very, very, she's a genius, really. I'm really impressed with her writing, her analysis, her research, how she expresses herself and her opinions. It's really a thing of beauty to watch as a lawyer watching a judge. Somebody who I think is on the short list for the Supreme Court, as I've said before. And Judge Meidas, who's the trial judge on the other case involving whether Donald Trump, because of his actions that he took inside or outside of those official duties while president, that led to the bodily harm, injury, maiming, and death of Capitol Police, House of Representative members, and others, where he's being sued civilly under the KKK Act. Yes, it's an act. It was a statute that was passed during Reconstruction to ensure that people's civil liberties are not being violated. And from a civil standpoint, Judge Meidas made that ruling 2 years ago, that the immunity would not, there was no immunity civilly for Donald Trump to avoid being sued because he was campaigning and he was clearly outside the outer boundaries of his official duties as a president, however you define them. Now, I don't know why the appellate, I want to hear your opinion. I don't know why the Court of Appeals sat on that for so long. The case just moved along at the trial level. There was no stay in place. And so the Meidas like preparing the case for trial. I mean, he's talked about having a trial in 2024 on it. And then finally, between you and me and the audience, after a lot of press over the last week or two, media coverage saying, where's that order? Why are they still sitting on that? We're turning into January here. Why hasn't that appellate court ruled those three people? And a lot of head scratching about it. Suddenly it popped out earlier this week, and hours later, Judge Chutkan put the finishing touches on her decision about whether criminal conduct of a president in this context and what's been charged in the indictment, which is not First Amendment protected speech, but as alleged, but is criminal conduct outlined in paragraph after paragraph in excruciating detail, excruciating for Donald Trump, in paragraph 10 of the indictment, in paragraph 3 of the indictment, listing the unindicted co-conspirators and all the things of conduct, elements of conduct, not speech, that they did. And the judge Judge Chutkan said, okay, I've got the ruling that just came out in the case involving the civil suit against Donald Trump, which said he doesn't have presidential immunity because he's a campaigner in chief only. At that point, he's outside his official duties. I think it was even easier for even if that ruling, let me put it this way, even if the DC ruling had not come out hours before she issued her ruling, I don't think anything at all would have changed in her decision-making. It just gave her one more piece of steel to undergird her analysis and to show her she was right and her bosses said so. So for you, I know you're gonna cover Chutkan more too, Ben. Why do you think what was with the delay for 2 years almost with the appellate court on the civil issues?
I think there was a lot of cases where this had an impact. There was a lot of consolidated cases. I mean, you had also, Judge Amit Mehta made this ruling It was remember the ruling by Ameta? We covered it. I think it was in February of 2022, Popok.
Right.
And it was a 112-page order
Right.
with massive implications on this doctrine of presidential immunity, lofty implications on the scope of presidential powers in civil cases. I want to emphasize that again. In civil cases, analyzing, and we did it in an abbreviated version here for Legal AF, Nixon versus Fitzgerald, Jones v. Clinton, the interplay between them. And so the briefing here took a significant period of time. There was a lot of amicus briefs that were filed, friend of court briefs that were filed here, a lot of voices wanting to have their own positions heard. And I just think the court had to come out with a very thoughtful order. It was an interesting composition of the panel here and how they kind of grasped with it. I mean, you had a Trump judge on the panel, Judge Katsas, who, if Judge Katsas is holding that there's no immunity in this setting, that's probably the most devastating news for Donald Trump, that this was a 3-0 opinion with Judge Rogers, a senior circuit judge, and Judge Siri Vasan, who's
sorry, I didn't mean to interrupt. Go ahead.
And Judge Srini Vasan, who's the chief judge. So you have the chief judge of the DC circuit, you have a Trump judge, and then you have a Clinton judge. That's why, to me, this ruling is extra devastating.
You want to turn to Chutkan?
Let's turn to Chutkan, and here's the distinction I want to make.
Yeah, do that.
So in the DC Circuit Court of Appeals case, that was dealing with a civil case, right? These were lawsuits for monetary damages against a president or former president, and the doctrines attendant to immunity in a civil case is defined by the Fitzgerald case that I mentioned and the Jones-Clinton case right there. But that's civil. What really has never been tested before until Judge Chutkan, okay, well, now what happens in the criminal context? Do the same doctrines of presidential immunity apply in the criminal context? And Michael Popok, how did Judge Tanya Chutkan address that and answer that?
Yeah, and I thought she picked up where where Nixon and Fitzgerald left off. People at home might be thinking around the country, Nixon and Fitzgerald again? Different Fitzgerald. It wasn't JFK. It was the guy that has been outlined. There was a civil servant that was suing. But even there, they anticipated the what if. Sometimes Supreme Court cases are different than trial level cases because judges or the majority decision tries to anticipate the future and telegraph where they may be. And even though it was a closely held, 5-4 decision, even Nixon v. Fitzgerald anticipated a world of a criminal president and gave the message like the ghost of Christmas past speaking to Judge Chutkan. So I think using what was already embedded within the analysis and the dicta of the Nixon and Fitzgerald case, combined with her own, she did two things in her order, which again, I can't, by saying that her order was masterful, I am saying that among the writings that we've seen of judges, and you and I read these things for a living and for our show and Hot Take, it does stand out as being valedictorian. I mean, it was really well done and spot on, and no word was wasted. It was like just efficient in its devastation, which, it doesn't have to be prolix. It doesn't have to be thousands of pages to get to the bottom of the point. And she was trying to accomplish two things. One, she was telling Donald Trump and his lawyers, you got to do better than what this constant refrain of the Biden administration is prosecuting its leading candidate against it in the election. It's a version of an election interference. It's completely unsupported. No backup for that. No support for that. You got to stop. And you got to stop telling me that what I read in the indictment is to be ignored, and you'll tell me what the indictment says and how you put it through your First Amendment filter, and everything in the indictment boils down for the Trump group and the Trump lawyers to that's First Amendment, that's protected First Amendment. All social media, talking, making comments, going after the election results, that's all First Amendment. And she's like, you got to stop. You got to read the indictment. First of all, she reminded them at the beginning two things that I love. One, Donald Trump's an indicted criminal. An indicted, who could be convicted criminal. She said he's indicted in 4 counts, felonies, first line of the order. And then she says to him, as a trial judge looking at the indictment, I have to accept everything in the indictment as true. And my powers to dismiss an indictment are very, very limited. And so you got to show me where this privilege comes from. And it's not helpful, she's telling the Trump lawyers, to distort and create a straw man out of the allegations of the indictment, because I can read and I can go to paragraph 10 where all of the conduct, this is about conduct. This isn't about First Amendment speech alone. Every crime has some sort of speech, or as I joke, we're not charging mimes with committing the crime, or mental telepathic people, I like you to do this, but you don't say it out loud. Every conduct or crime has speech, but not all speech is protected by the First Amendment. So it's like, stop. Then her second thing that she did so masterfully in the motion, in the order, is to take apart brick by brick the historical and framer analysis, founding father framer analysis of the Constitution, and the president and the protection of the president, because they did it. And they wrote in their brief, oh, Alexander Hamilton, once in the Federalist Papers, and they distorted something that Alexander Hamilton said. And she said, and you're also, not only there is not a presidential immunity clause in the Constitution for a good reason, but the tyranny that our founding fathers were worried about, indicting and prosecuting a former president for crimes he committed while president, is exactly what they would have expected. And then she turned to cases like Nixon v. Fitzgerald. For instance, they argued as one of their fallback positions, the only way a president can be tried for crimes is through the impeachment process in the Senate. She said, that's ridiculous. That's not even the plain reading of the Constitution, and the clause that you're citing doesn't even say that. So I don't know, I guess when they write it, like you and I practice law. You and I have looked at each other's writing. And if something doesn't make sense or is inconsistent with the facts, the Constitution, the statute we're relying on, you and I will call each other out. Like, that's not what it says, Popok. It says this. You're misquoting it. That's not what that complaint says that we're up against. And so we go, you're right, because you don't want to lose credibility with the court in easily dispatched arguments that take 2 seconds to knock over. You want to have things, because you're going to one day be in front of an appellate court, and they're going to go, that's not what the indictment says. The indictment said, and then she got a chance to outline everywhere in the indictment and all of the bad conduct, from the fake electors that Donald Trump was involved with using, the pressure campaign on Mike Pence, Donald Trump inserting himself into phone calls and meetings with members of the state legislators, state legislators, speakers of the House, that type of thing, in order to try to change the outcome of the election. And she said none of that stuff, citing back to the case we just talked about at length in the civil KKK case, none of that stuff is part of your presidential powers. All of that stuff is well outside of it. And we can't live in a society, this is her concluding thought process, or this is the line of analysis that's pulled through the entire briefing, which is, we are a country of law, not men, and no one is above the law. She said that from day one when she did the arraignment and off the indictment. And a person that can make his own law, which is what Donald Trump, and say whether he's complying with law or not complying with law, he gets to say that because he used to be the president. That's just a fast track to the road to tyranny. And I'm not going to allow that. And when you and I said it yesterday in a hot take, when we reported on this particular resolution, that I am convinced, I was before and I am now, that Tanya Chutkan, among all of the judges that are handling matters where Donald Trump is on the other side of the V, where he's the defendant, especially in criminal matters, isn't crushed by it, but feels the weight of her responsibility and in history to get these decisions right and to make sure that the voters in November have a jury verdict, either a conviction or an acquittal for Donald Trump. And she's not going to let anything, including improper analysis, improper recitation of what's in the indictment, claims of prosecutorial misconduct or selective prosecution or Joe Biden vendetta campaign against Donald Trump. She's not going to let any of those paper arguments get in the way of what her poll star, which is, we're going to trial in March unless my bosses at the appellate courts tell me I'm not. And we're going to treat this case like any other, with the bumpers around it, guardrails around it to protect America. So we're not surprised, sitting in our seats as podcasters and doing this work, that she rejected all of these, and she's about to reject all of these motions to dismiss the indictment and move this case towards the March prosecution. The question now is, with this order in place and her analysis so eloquently laid out, the next step on the train is obviously an appeal by Donald Trump. Comment on whatever you picked up with Chutkan that you thought was really fascinating. And what do you think happens next when a new 3-judge panel, because these 3-judge panels rotate, they spin, you don't get the same panel to decide all the issues. You get a different random panel. What do you think the next 3-judge panel does? Do they stay the case in order to get the decision made on this immunity issue? Or do they say, that's an interesting academic issue, continue with your trial, we'll get back to you on the immunity issue when we're ready? What do you think happens?
So ultimately, the outcome seems already determined in terms of on the substance, not on the issue of the stay, based on what the DC Circuit already ruled in the civil case that we were talking about before we were talking about the criminal case. Why I said there's double protection is that Judge Chutkan's ruling is based on the fact that this is a former president. This is a criminal case. If you look at the text, structure, and history of the Constitution and immunity, it does not apply to criminal cases involving former presidents. It's narrow on that issue. This should be a no-brainer. But then, even if you said, Judge Chutkan, you're wrong on that, and the panel says, we think that the text, structure, and history provide something in the criminal context that's quasi-analogous to what we see in the civil case, like a Fitzgerald. The double protection I'm talking about is, well, in the decision just reached by the DC Circuit Court of Appeals, they said that Donald Trump's conduct is election related, that Donald Trump was trying to overthrow the results of an election, and that clearly falls outside the outer perimeter. So Popok, substantively, I think that it's the Judge Chutkan's decision is buttressed by what the DC Circuit did, and I think that they'll agree with her that the Fitzgerald doctrine does not apply and presidential immunity does not apply to former presidents in criminal context. Now, on the issue of a stay, on the issue of should this case be delayed pending adjudication on the immunity doctrine with emergency briefing, here's the thing. This is an interlocutory appeal, and the case law is pretty clear that immunity issues are always to be determined as threshold issues before trial. So the panel's going to have to order some sort of expedited or emergency briefing, right? Because as you saw with the last case that we were talking about, Judge Amit Mehta's decision, the federal judge in the civil case, made that ruling in February of 2022. There wasn't a decision reached until December 2023. That becomes the key issue, Popok. And look, if I were to place a bet on it, I would say there's about an 85 to 90% chance that there is no stay or delay of the Washington, D.C. case, that I think the judiciary wants that case to go to trial. the only hedge that I have is I need to see what that panel is and who that panel is. If that panel is made up of, Trumpers and George W. Bush, and there is no countervailing voice on it, I just don't know how that panel is going to react. So my equation changes if I know the panel, but I will say this. In the DC case that addressed the civil issues, and with their precedent established, Judge Katsas, a Trump lawyer, was one of the people who found that there was no immunity in the civil setting. That doesn't mean that Katsas wouldn't. I don't know how Katsas would rule on the issue of a stay pending adjudication on the immunity issue. So overall, that's at least how I think about the process. But I would put it at an 85 to 90%.
Let me comment on that. I agree with you about the panel. I think ultimately, though, any panel, given the most recent precedent, is going to find in an expedited way that without a stay, I agree with you that not just for Donald Trump, but for the future, the next Donald Trump, God forbid, or Trump as Donald Trump, and then similarly with the Supreme Court, first stop on that train after that ruling, just like the gag order rulings or this or that. We're still waiting on the gag order ruling from the District of Columbia. I think the Supreme Court is going to be less interested in the gag order now. Assuming the DC Court of Appeals, which I'm in the 95 percentile, that now, especially since New York just gagged him again, we'll get there later, Trump, that they're going to re-gag him and find Tanya Chutkan properly. They're going to support her again. She's rarely overturned or vacated or reversed by the appellate court. I think the first stop on the train could say, I'm not going to stay the case. You'll just do a normal appeal, or he turns it over to the full Supreme Court. And I think that there's at least 5 votes for the future of our republic to find that an indictment like this one, alleging criminal conduct of a president trying to cling to power and stop the peaceful transfer, if can be the subject of an indictment and a criminal prosecution. I believe that's the law that 5, at least on the Supreme Court, is going to want to set in this area, following up on the Clinton case, the Paula Jones Clinton case, and the Nixon v. Fitzgerald case. And I think that'll go quickly. And again, to your point, I don't think anything derails. I just don't think it's going to derail the March trial.
I want to mention this about Judge Tanya Chutkan, and this is why we've been following all of the judges in Washington, D.C., all of their rulings. If you go back to a legal AF that we did around, I don't know, when was the Judge Chutkan order issued? November or December of 2021, or around that time period. Judge Tanya Chutkan ruled back then the following. She said that presidents are not kings, and Donald Trump is not the president. He retains the right to assert that his records are privileged, but the incumbent president is the one who holds executive privilege. That was regarding the early days of the January 6th committee, when they were requesting documents and Donald Trump tried to block it, claiming executive privilege. He said, as a former president, he has the right to assert executive privilege. So Judge Chutkan's ruling back then in November or December of 2021, whenever that ruling was, I think it's November 2021, early November 2021, that really set the tone for the January 6th committee getting these records. And we covered Judge Tanya Chutkan doing that. So compare her language back in November 2021, presidents are not kings and plaintiff is not the president, to the most recent line in this order that she says. She goes, defendant's 4-year service as commander-in-chief did not bestow on him the divine right of kings to evade the criminal accountability that governs his fellow citizens. No man in this country, not even the former president, is so high that he is above the law. So when we make these predictions on Legal AF and on the MeidasTouch Network about why we think the judges are going to rule certain ways, how they're thinking about the issues, it's why we track all of these decisions, because you can interlay exactly what she was saying back then, and her intellectual and constitutional consistency with the ruling that she just made on Friday, rejecting Donald Trump's claim of absolute presidential immunity. She also rejected Donald Trump's claim of other constitutional immunities. Donald Trump tried to assert the First Amendment, due process, and double jeopardy as defenses, and she just said on all of those that they're basically frivolous as well. I want to go from Washington, D.C., Popok, though, to New York and discuss what's the latest on the gag order in New York. Of course, Judge Engoron back on October 3rd, then on October 20th, and later on, later in October, imposed this gag order on Donald Trump not to attack his principal law clerk. And then when Donald Trump's lawyers later in October started attacking the law clerk in the courtroom itself, the gag order was then imposed on Donald Trump's lawyers, Christopher Kise, Cliff Roberts, and Alina Habba. We'll talk more about Alina Habba later in the show. Then Donald Trump sought an emergency temporary administrative stay to press pause on the gag order. And last week and the week before, when that occurred, Donald Trump was bragging about it. The appellate division said that I'm the greatest, and they said that I'm right, and they said that Judge Engoron was wrong for imposing this gag order, and look at a big win. Popok, you and Karen Friedman Agnifilo took right to our digital channel here and said, no. That's a temporary administrative stay. Donald Trump's taking advantage of a loophole in the law that basically provides for these temporary stays on things like this. It's the same thing, actually, that the Washington, D.C. Circuit Court of Appeals did as well. Like this is something that, unfortunately, when there's good faith belief in people following the law and when the constitutional and judicial norms are followed, this is just part of our process here, for better or for worse. And we're seeing with Donald Trump, it's for worse because he exploits it. That's why the appellate division only granted this temporary stay with this Article 78 lawsuit that Donald Trump filed. Remember, then the New York Attorney General, through the Assistant Solicitor General, filed a brief with the appellate division, the court that oversees Judge Engoron, laid out 275 pages, single-spaced, all of the threats that Judge Engoron, his principal law clerk, were receiving, immediate, direct threats. Donald Trump's response to that is these threats may be vile and they may be, reprehensible, I think were the words. But Trump's lawyer said Trump shouldn't be, just because Trump's a heckler, you shouldn't apply a heckler's veto to Donald Trump. He should not be responsible for people following what he says. And then the Donald Trump's lawyer said that there's not any immediate threat to the principal law clerks, despite the fact that there was a declaration submitted from a safety officer of the court saying that there's an immediate threat and they need to get security for Engoron and Engoron's principal law clerk. So that sets the framework for what the appellate division did in upholding the gag order.
Well, there's a great example of what we do twice a week, only exclusively on the MeidasTouch YouTube station and channel right here on this platform. Give them a thumbs up, help them, and free subscribe get to their 2 million person target. They are a grassroots independent media company. They can't do it without you. And if you like that kind of debate, that's the content that we bring regularly on the MeidasTouch Network. Wednesdays and Saturdays, 8 p.m. Eastern Time. It's the only place you can catch the top podcast called Legal AF, at the intersection of law, politics, and justice. We do it just like that, except it's about an hour-long show. You can then pick it up on audio podcast platforms wherever you get your audio podcasts from. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.